Well, kia ora koto. No America aho no te timatanga, ko te tai tatoku maunga, ko waitaki toku awa, ko otatahi toku kainga inai nei, he roia toku tunga mahi o Perryfield Lawyers, ko Stephen Mo toku ingoa, no reira nā mihi kia koto katoa. It's really wonderful to welcome so many of you to this call. This is Sophie, and we work very closely together on incorporated societies and not-for-profits, charities, but also on purpose-driven structures. So sometimes they're businesses, sometimes they're charities. On this call, we are going to be deep diving into the changes being introduced by the Incorporated Societies Act 2022. So I'm assuming that you're all here for a reason. Some of you will be from incorporated societies. Some of you will be advisors or professionals who provide input to incorporated societies. And I don't know, some of you may have just thought, oh, I'll learn about incorporated societies. So we welcome you all for the different reasons that you're here. And our role, I guess our heart behind doing this is that we really want to empower the sector and empower people who are involved in incorporated societies with the information, because there is quite a few things that are happening, quite a few changes coming. We're going to get underway. What we've done is outlined 10 key changes, which we think everybody should be aware of. So the format that we're going to do is I'm going to give a little introduction to set the historical context of why we're having this conversation, what the timeframes are in terms of changes which are coming, and then also looking at what are the key points that we think you need to know. So some of you joined early and you've been typing in the chat already the city you're in and what the weather's like. So now I know you know how to use the chat function. So we would really welcome any questions. And the reason why we want the questions is that we think this is an amazing testing ground of what everybody out in the community is asking and wondering. So if you are willing to share what is your question, that actually helps not just you, but potentially dozens of other people. And the reason is that we are putting a Google Doc with every question we've received. What are we up to now? Do you remember?
Up to question 27.
Yeah, so we've had 27 questions so far. This is the third session that we've run for the sector. And yeah, each 27 different questions. So you might actually find by looking at that document that the question you've got would be answered, but we're really keen to hear from you. And equally, as we're talking and we're going through the 10 key changes, then you might reflect and go, well, what about this or what about that? So yeah, we just want to encourage that. Towards the end, I think we'll open it up as well. If you wanted to talk, then we can, we can use the video function of Zoom and you can ask some questions as well, but feel free to type them in and then we can even respond to them as we're talking. So just the background, before we talk about the background, just a really brief thing to note. Sophie and I were based here in beautiful Ōtautahi, Christchurch, but we're assisting clients across the country. So I think, given the pandemic, we've all gotten used to Zoom. We're, I think, a bit more flexible than we were in the past in terms of having people giving us input from wherever they happen to be. So we were on a call just the other day with somebody up towards Whangarei. We were talking to Nelson, Wellington, Dunedin, like we're assisting people all over. So just want to make that clear that even though we're based in Christchurch, we're actually helping people across the country. And I mention that because I know many of you are somewhere else in this beautiful country. And we're both lawyers. We're working in this law firm called Perryfield Lawyers. I won't go into all my background, but I started my career as a corporate mergers and acquisitions sort of lawyer, and then 6 years ago transitioned into purpose and impact. So we do a lot of things for this sector, including hosting monthly impact calls, where we hear from somebody different, usually 2 or 3 people, as a way to get out of our silos of thought and download what's going on for another sector. So in the last call, we had the head of the Akina Foundation, Nicola Nation sharing, and they are concentrating on social enterprise. And we also had Lisa Foster, the head of New Zealand Rare Disorders. So it's a chance to just hear from what other people are doing. And yeah, we're trying to resource the sector. Hopefully you've seen the information hub for incorporated societies, but we've also done a bunch of other things like a Charities legal handbook, a social enterprise book, a capital raising guide, a whole bunch of stuff. So that's the little bit of background, but just trying to set the context of who we are, because it's always hard, you know, to do this, but hopefully it gives you a sense of what we're about and what we're trying to do. So into our topic of the day, incorporated societies. And probably none of you have read or seen this, but this is from the Unclassified Societies Registration Act of 1895. So this is the original origin of incorporated societies in New Zealand. And the thing I have to say about this is they knew how to do things in 1895 because it's literally this big. It's page 1, page 2, and page 3. So there's 18 sections. So by contrast, the Incorporated Societies Act 2022 is a little bit bigger, 270 sections. So there's obviously a step up in terms of what's required. The current act is the 1908 Act. It doesn't have a little nice logo like the 1895 one, but it has 40 sections. So the point is that we've gone from the, you know, very old style, very old acts to a new act. And the big change is that every incorporated society is affected. And when we've done the research and chatted to Charities Services, and my contact there confirmed there's, you know, about 24,000 incorporated societies. So that is a lot of entities out there that will be affected, every single one of them. And the reason is that you actually have to re-register under the new act. So if you take nothing else away, just take away the principle that there is change coming that is going to affect you if you're an incorporated society. The other thing is that we have a couple slides. We're not showing them here because we feel like that distracts away. Sometimes PowerPoint is not our friend. So what we're going to do is email the slides afterwards so that you can then have them. So don't feel like you have to frantically be noting like, oh, key change number 1 or 2. And we're also including the cheat sheet, which is our speaking notes or the points that we're going to be making. So you'll be able to actually download those and look at them yourself after the call. So that is the format and the context. So the first key thing is that these incorporated societies are going to need to re-register by the transitional date. And that's going to be about 2.5 years. Oh, by the way, keep a note on the chat because Sophie has another computer set up right beside me, and she's going to be putting in links to different things that I'm mentioning or that she mentions so that you can just kind of click and find things. Hopefully makes it a little bit easier. So yeah, there's a transition period. So this is actually good news. It's not like you have to rush off and adopt new rules and it's all going to be done by, you know, October or something. There is going to be quite a long transitional period, which is good. So it's likely going to be the 1st of December 2025. So basically, like, what's that, like 2.5 years away, or from when some regulations come into force 2.5 years after that. And maybe that's a point to mention, is that we're doing our best to tell you everything that you need to know, but they haven't yet released all of the regulations that back up this, you know, 270 sections in the Act. So yeah, it's like the advertorials, you know, but wait, there's more. So you've got all the sections, but then you've also got these regulations which are going to be coming in. Yeah. So if you don't re-register, then the incorporated society will basically cease to exist. So that's why it's going to be important that people do keep on top of this and make sure that you do get things, that you do re-register in time. So the top 10 changes to consider, we're just going to run through these. Were there any questions so far that we need to look at, or no? We'll just keep going. That's great. So the top 10 things that we think that should be on your radar. The first one is that these new rules are required. And I actually think, so actually across all of these changes, across all of the 10 things that we think you need to know, I would encourage you, assuming some of you are from incorporated societies, I know there's going to be a temptation to approach this in a, oh no, more regulation. Oh no, we have to take some action. My encouragement to you would be take the glass half full approach, which is actually, this is an opportunity to revisit our grounding rules, the foundational core of how we exist and why we exist. And the reality is, I would suspect that many organizations haven't even looked at their rules for a very long time, because the Act has been around since 1908. We've had some people say, we haven't even, they're in the bottom drawer, let's put it that way. And something that was written in 1972, actually, when we read our rules, we realize that we haven't been complying with what we were meant to be doing in terms of how do you call meetings, or some election procedure, or what is our purpose? So it's actually a good opportunity for organizations to hold up the mirror, look at themselves and go, this is a chance for us to rewrite our rules to actually enshrine how we want to operate going forward, rather than how we, in theory, operate based on rules that were drafted a long time ago. And so I kind of view it as, this is a refreshing exercise, and it's a chance for you and your members and others to actually say, this is a good point to look at our purpose. Like, what do we exist for? Why are we here? So you're going to have to update it. And there, I can tell you what, even if you adopted new rules last year, there is definitely going to be something which will be in the new Act that you're going to have to reflect, because there's a lot of changes. So just to give an example, there needs to be provisions about membership, governance, general meetings, dispute resolution, purposes, winding up. Some of you will have rules which cover some or all of these things, but the reality, and we've been reviewing multiple rules now, haven't we? And basically all of them, there's always going to be something that actually just needs a review. And I'm not meaning this in a scaremongering way. I'm just saying this is just the reality. There's 270 sections in this Act. There's a lot of things that they are updating. Again, you can tell I'm the glass half full sort of person, but a lot of what they've put in is actually existing law. It's just never been written down in the statute. So we're going to get into that in a second. But the first thing is to recognize that new rules are required. And we've done some articles about the core elements of that. The second thing, Sophie, you can have a go at that one.
Thanks, Stephen. So the second top 10 change required under the new Act is that the new Act requires a committee. So previously, and under the 1908 Act, a society didn't need to have a committee, it only needed officers. But now under the new Act, a society must have a committee, which includes 3 or more qualified officers. So the new Act also sets out the definition of an officer, which includes that the officer must be a natural person, so a real person, have consented to being an officer, and have certified they're not disqualified under the new Act. Now, the new Act also includes a long list of disqualifications, but they are very similar to that in other legislation regulating other entities. So it's things like the officer can't be an undischarged bankrupt. So like Stephen said, it's not a big change. It's just more so written down now that that a society needs to have a committee. Awesome. Back over to you, Stephen.
Yeah, and actually we had a great question yesterday, I think it was. We were talking with
Yes.
somebody and they said, well, we have, what was the term that they used? Was it just
A
board?
Yeah.
Yeah, they said, we have a board. Are we complying or not? And the answer was, yes, you are. It's just there's different terminology. And the Act talks about a committee, but our view is that if you call it a board, that's fine. It's just a different name. Okay, and then the third change that we wanted to highlight for you all, you're gonna love this one, but it's about officers. So one of the questions we're getting quite a lot is, what about the officers? What about duties? And the answer is that the Act does codify. So codify means it already exists as law. It's what we as lawyers would call common law. So it's not written down in a statute. It's just the judges would refer to it as common law. So the Act codifies existing common law duties for officers. So yes, if you're an officer, you do have some duties that you need to be aware of. So these include things like the duty to act in good faith and in the society's best interest, the duty to exercise powers for a proper purpose, the duty to comply with the Act and the Constitution, duty of care, and then two, which are a little bit interesting, is duty not to create substantial risk of serious loss to creditors, and a duty not to agree to the society incurring obligations that it cannot perform. So if you go and look at the Companies Act, you'll find that sections 131 to 138, they are dealing with directors' duties in a company context. And there is a bit of a mirroring going on here in that there's talking about the duty to act in good faith and in the society's best interests. That's very similar to section 131 of the Companies Act. And the reason is that they're trying to upgrade the standard that's required of officers of incorporated societies. So my view is that this isn't something to be afraid of. This is something, these duties already applied, and it's just now going to be clearer for officers what are our duties. So it will be hopefully helpful for all of your officers to be aware of, okay, I need to make sure that we are, exercising our powers for a proper purpose. Generally, if an officer is acting in good faith and in the society's best interests, my feeling is that's like the Northern Star. If you're following that, then all the other things fall into place. Because if you're acting in good faith, so that means that you are acting responsibly, using the information you have, you're acting in the society's best interests. So that's getting rid of conflicts. It's making sure that you're thinking about the society. Then probably everything else is going to fall into place as well. Keep you on the straight and narrow. The last two about risk of serious loss to creditors and incurring obligations that it can't perform, that was actually raised in the final kind of reading of the bill. And there was some criticism of including those because it was felt like they were very commercial terms. And often, as you all know, I'm sure, incorporated societies, there's a lot of volunteering going on, and it's not profit-making enterprises. So why would we have these here about risk of loss to creditors? And the answer to that is that they're going to evaluate it and see how it goes. They may amend it. But the other outcome of this, I think, is that it's probably good practice to look at whether you have insurance in place for officers. And that's called directors and officers insurance. So it's going to depend on, every context is different, like what do we do as an incorporated society? Is there much risk involved? But it might be helpful to look at your policies and see, should we be having some insurance? Great. So change number 4.
Awesome. Change number 4 changes to membership. So as I'm sure you're aware, under the old Act, you needed 15 members to register as a society, while under the new Act, you only need 10, which is great, except there is a continuous minimum membership requirement under the new Act. So you always need to have at least 10 members. So a body corporate still counts as being 3 members, but it's really important for smaller societies to keep an eye on that 10 membership minimum, and may even be a reason for a smaller society to transition to a different entity structure that's better suited to them, like a charitable trust, which Stephen will talk about later. But if a society does drop below that 10 member threshold, the registrar may intervene and get in touch and give that society some time to bump up their membership numbers. So yeah, smaller societies will need to be aware of this and may need to bring on some family members or friends for a short period of time while they undergo some bumping up their membership numbers. And the new Act also introduces a requirement for members to consent to being a member, and the society will also need to keep a register of members. This seems like good practice to know who your members are and for them to agree to being members and to have their details. So nothing too out of the ordinary there. It's just in the law now. And back over to you, Stephen, for change number 5.
Great, thank you. Change number 5 has to do with conflict of interest procedures. So we're getting into this. So this is section 62 to 73. And this, so conflicts of interest, I think we all, particularly in New Zealand, we all wear multiple hats, right? So there inevitably become conflicts of interest, particularly if you're involved in a community endeavor. And let's say that there's a company which is services are being provided to the incorporated society, and you're also a director of that company. Like, what do you do? How do you deal with that? So it's essentially this: you need to disclose. And that is actually probably good practice for any organization. If there is a conflict, and I would even go so far to say, even if there's a perceived conflict, then the sanitizer to conflicts is disclosure. So letting people know about it. Then there's no question later on, like, oh, we didn't know that you were a director of this entity that we just contracted, to provide a service. Like, and so you just want to avoid anything that at some point in the future could be a headline, right? So the way to do that is to disclose. And so if an officer is interested in a matter, then they can't vote on it or take part in committees which are considering it or sign documents. I guess it's conceivably possible that more than half of a committee might be conflicted. And if that was the case, then there's rules about calling a special general meeting to determine what would happen in that, situation. So some of these procedures, they can be altered by your constitution. And so it's important to think about what is it that you want to have for a conflict of interest? Like, how do you want conflicts to be dealt with? And maybe we probably should have said at the start, that's kind of a general principle here, is that the Act lays out a baseline, and then the Constitution allows you to say, well, I like that part, but I don't like that part. Let's change it in our Constitution. And so I view, again, this is a positive way that you can actually have control over what it is that your incorporated society is actually doing. So yeah, that's just another point to note, is that you can alter quite a lot in your constitution. So yeah, change number 6.
Thanks, Stephen. Change number 6 is that the new Act requires a society's constitution to include dispute resolution procedures, including provision for how complaints can be made. So as Stephen was saying before, the Act sets out a baseline requirement, and it also has its own dispute resolution procedures that a society can choose to adopt, or a society will be deemed to have adopted them if they don't say anything else in their constitution about disputes. Otherwise, if you've already got dispute resolution procedures or you want to make your own, then you can do that as long as they're consistent with natural justice. So we ourselves have been working alongside our litigation team to develop some well-rounded dispute resolution procedures. So there is that option there as well, and that flexibility to set out how you want to resolve disputes. Back over to you, Stephen.
Great. We're making our way through here. Number 7, if there might be some of you who are accountants dialing into this, so you'll be happy to see that we are mentioning accounting, and that is in the form of financial reporting. So there is a new section, part 3, subpart 7 of the new Act introduces new accounting standards. And essentially, the incorporated society needs to prepare financial statements according to the standards that suit the size of their society. So it's not all the same for every incorporated society, which I think is positive, because we all know that some are going to be much larger and some are going to be like very, very small. So you don't have the same standards if you've got, for example, what's called a small society. So that's less than $50,000. A small society would prepare their financial statements according to generally accepted accounting practice. And it kind of goes into detail about this. I guess my encouragement to you would be, if hopefully you've got an accountant who's providing you input or advice, involve them in the process of looking at what your accounting standards are and what they'll be going forwards, because I think that's something that, you should be aware of. The XRB has done quite a lot in this area. So XRB sets the accounting standards in New Zealand. It's like a government body. It stands for the External Reporting Board. And so they're the ones who have published a lot of information, and it's all free. So I'd encourage you to have a look at that. As a side note, I'm actually on the XRB advisory panel, which provides them input from the sector from time to time. And I know that they're really interested to hear from people about what is your experience of accounting and standards. And they have a consultation right now about Tier 3 and Tier 4 charities and how things could be improved when it comes to standards. So if you're interested in that, just maybe you hopefully all have my email now. So just hit reply and ask me, and I'm happy to direct you to that, because it's a way to give input to the actual regulator, about what is the shape going to be in the future. Yep. So there's a couple more things, like when you have to file returns by and statements by, but we won't go into the detail of that. It's just so it's on your radar that this is another thing which is changing. Number 8.
Awesome. Thanks, Stephen. Number 8 is that the new Act provides for amalgamation procedures. So what this means is it'll allow societies to join together. So either one society into the other or into a completely new society, which is great for smaller societies, or say where a society has several branches and 2 of them need to combine. So the new Act sets out a simplified version of the Companies Act amalgamation process. So that's really exciting, Stephen, just to have that process there for societies, just to make things easier when they're joining together.
Yep.
And back over to you.
Thank you. Yeah. The amalgamation, it sounds boring, but you're right. At least for us as lawyers, it's like, this is actually quite exciting, because quite often societies in the past have maybe honestly gotten to the end of the life cycle of what they can do and achieve in the community, and maybe needed to amalgamate and join forces with another, but there hasn't been clear mechanisms for that to happen. So this is now remedied in this change. Number 9, in terms of our key changes, we've got as enforcement. And this is basically that there's some civil law enforcement provisions that explicitly state the orders that a court can make. And also, this is the key bit, who can apply for a court order. So this could help in the future. For example, if there's a member of a society who wants to apply to the court where they believe the Constitution has been breached, it's just a bit clear about how that would happen. So that's quite good. And one of the questions that we've been getting a lot is what about disputes? So we haven't actually got that as one of our top 10, do we? We've got the conflicts of resolution procedures, but how do you deal with disputes? And so that's an interesting one as well, because if you don't put it in your constitution, then the Act has provisions about how disputes are handled. But I'd encourage all of you to have a look at what the Act says, but then probably have a bespoke mechanism for what you do with disputes. And unfortunately, sometimes, and I'd be interested in the wisdom of the room here, but unfortunately, sometimes there can be disputes that arise in incorporated societies. People are very passionate about the particular cause or what it is that the society does. And as a result, there can be some tension between the directions and things. So it's just good to have clear mechanisms for how disputes will be dealt with. And you get to do number 10.
Number 10, we're ending on a high note, offences. So the new Act sets out some criminal offences. There's some lesser infringement offences for less serious matters, and include things such as not notifying the registrar of changes to the Constitution. In a society that commits an infringement procedure offence may be liable to a fine of not exceeding $3,000. And then the new Act also sets out some serious offences, such as making false statements, falsification of the register of records, dishonesty, and serious things, which I'm sure that none of you are doing in your societies. So these provisions, they add to the dishonesty provisions in the Crimes Act, and some of the more serious offences could result in a fine of up to $200,000 or a term of imprisonment of up to 5 years. So again, hopefully this is something that does not come up for any of you at all, but we just wanted to make you aware of the fact that there are new offences in the new Act. Back to you, Stephen.
Perfect. So those are kind of the 10 highlights that we wanted to draw. And like I said, we've done some slides which then have the notes talking about all of these. So hopefully you weren't scrambling all the notes. We will circulate it. The intention of this is obviously, hopefully coming through, we want to empower people to actually know, what does this all mean? And we're aware that, it's going to affect everybody. You might as well upskill and have the background so that you can then take things forward within your own context. But when we send it, you'll see there's like, here are the top 10 things, and then here's the notes for each of them. So hopefully that is helpful. So we wanted to, I guess, kind of get to the end here, but we had two other things we wanted to do. The first is we wanted to answer any questions. So feel free, now's the time to put something in the chat if you'd like to. If we don't know the answer, then we promise to investigate it and circulate the answer later. And we'll be updating the Google Doc on our information hub with any answers that we get to questions. So, but I also did want to touch on one thing, and it's a kind of a hard question maybe, so you have to listen to this with the right ears. But do you think that you are the correct structure? So the reason why I'm asking that is that sometimes, this is actually an opportunity to say, is the incorporated societies model the best for our entity going forward? A lot of you are going to say, no, it's definitely the right fit because we were set up in 1933. We have massive historical legacy. There's no way that we could change ship now and jump over to another model. But I guess my challenge is, this is the moment to at least ask the hard question. The answer might be, no, we're happy. Incorporated society works for us. But the answer also might be, we should explore it at least, because what you can do is keep your charity services registration number, but alter the model of entity that you are. So we've helped a number of organizations now transition. The main transition we're seeing is from incorporated society model to a charitable trust model. And so the reasons why people are doing this is that incorporated societies, and we've written an article about this for the Auckland District Law Society, which I think Sophie will put in the chat, and it goes into more detail. But the high level point is that incorporated societies are extremely democratic. That sounds wonderful, but also democracy sometimes means that there has the potential for them to be taken over by interest groups. So I've actually seen this personally. So this is a real story where somebody on a Friday night called me, and they're the president of the Incorporated Society, and they say, hey, Stephen, hope it's going well. We've got our AGM tomorrow. I heard some rumblings in the troops. I'm not sure. I'll give you a call on Monday, let you know how it went. Monday, phone call, different voice. You are not allowed to talk to the past president. They are gone. All of the previous committee is gone. There's now a new committee, and we are taking it in a different direction. And so it is possible for this to happen. And I've also seen situations where there has been controversy over elections, and people say, well, I was elected as the president. And then the past president says, no, there was incorrect procedure followed. I'm still the president. And who holds the codes for the bank account? Who holds all the information? It's the past president. And all of a sudden you end up in this big dispute as to who are the officers. And so it's just, I want to point it out. I'm so sure some of you have had this as well. There's just tendency to become quite political. And ultimately, I've seen some incorporated societies self-implode where it ends up a court dispute between the former committee and the current committee. Oh, but wait, who is the committee? You know, it just has that potential. So we're just raising it because charitable trusts, they can provide a different vehicle. If you think about going to buy a car, there's different vehicles. If you want to go skiing, you get a four-wheel drive. If you want to drive around town and look cool, you get a convertible, or maybe the other way around. But you can choose the type of vehicle depending on your purpose and your mission. So it's the same with legal structures. So the hard question maybe is our current legal structure the best suited to take us forward so that we can accomplish our mission and purpose in the best way? Because ultimately, we're here to serve the people who we want to support and help. So we just want to raise it as something to think about. I'm sure the vast majority of you will turn around and say, no, we're all good. But we've had a number of people approach us after these sorts of calls. And we've had about 120 or so people involved in some way over the last month. And we've had a number of people say, actually, this is a timely reminder that it might be a good idea to look at our structure and consider, is this the best for us going forward? So some of you are going, oh, that's interesting. Some of you are nodding off because it doesn't apply, but at least now you've got something to be thinking about. Great. And then the last thing, just before we jump into the questions, is we did want to mention the resources that we're putting out. So you would have seen the Information Hub. The first session we did of this is uploaded there. We'll put this session up as well. We've done about 12 different articles on the changes. We've made the last session a podcast as well, because I do a podcast interviewing inspiring people, which now has more than 300 interviews. So we've uploaded the audio of that for people to be able to easily access it. And then we have this Q&A document, which we're constantly updating depending on the questions that we're receiving. So we'll be updating it to reflect all the questions in this session as well. So hopefully you get the impression that there is information out there. We noticed, I think it was yesterday, we saw that MB and Charities Services are going to be running some sessions at the end of July. So we're planning to dial in and listen to what they have to say. Yeah, we hope that this has been helpful too. So just to raise these up so you can see it, this is the Charities in New Zealand Legal Handbook. We have put this out as a guide. So this would be something that could be circulated to officers of incorporated societies, just as reminders sometimes of what does it mean, you know, to be involved in a charity. We've also done a toolkit, which is kind of similar to that one, but has more of a focus on churches. So some of you might be incorporated societies, which are churches. That's kind of a focus on churches. And then we've done a startups legal toolkit, which might not be relevant directly, but actually probably has a lot of information if any of you are thinking of doing a for-profit entity, you know, within your structure, which is quite a good option. And then we've also done this one, which is the Social Enterprises in New Zealand, a legal handbook. So that's looking at profit businesses, but also purpose-driven. Yeah, I won't go into all of them, but we did this as well. It's a book about the future of business. And this one is like a capital raising guide. Like if you want to get money, where are you going to get it from? It's actually an interesting conversation for all of you. If you're in not-for-profit world, have you come across the term impact investing? Because this is a growing area where people are actually looking at, instead of putting my money, and I'm talking wealthy people, philanthropic, large foundations, instead of putting my money for, 3% interest rate with a large mainstream bank, how could I use my capital to actually have impact, actually have some good being done? And that's what impact investing is all about. So yeah, you can approach people and ask them to support your cause or your project, have some money making side to it, but then also see return in impact and financial return. I have personal experience of this, so happy to jump on a call with any of you who want to explore it. I'm involved with something called community finance, and our focus is on social housing. What we do is bridge the gap between philanthropic investors like KiwiSaver funds, so Generate, Simplicity, Pathfinder. They're all open to alternative investments. So we've raised $95 million in the last 2 years, which then goes to social housing. And we partner with community housing providers like Salvation Army or Habitat for Humanity or other amazing people doing the work on the ground. So I'm just throwing it out maybe as a blue skies thought to raise with your boards. Have we considered impact investing to further our cause, to keep the mahi going as another alternative to just, not just, but, being a not-for-profit, like, please, sir, give me more. So we hope that that's been helpful. I think what we'll do is hit pause on the recording, and then we will jump into the questions. And that way, if you want to come off of the muting and the video, then we welcome that as well. So I'll just hit pause, but want to say thank you everybody for joining. And if you're watching this, glad that you made it this far, and we'll put some resources on the chat.